Assalamualaikum and good morning, everyone. I hope all of you are always in good health. So I would like to continue our presentation for today. There are two methods for settling construction disputes, which are formal and informal. For formal method, we have arbitration and litigation, and for informal, it have four other methods, which are negotiation, conciliation, mediation, and dispute review board. So I will start with explaining about formal method first. Next. So first is arbitration. Arbitration involves one or more neutral third parties as an arbitrator who conduct hearing according to specific specify rules and procedures to determine who is right or wrong on selected issues. So the decision can either be binding or non-binding on all of the parties when deciding which parties are to reserve and award. Next. So this is the arbitration process. First, the parties file the cases and then they selected an arbitrator. After that, the process of preliminary hearing and scheduling order, discovery process, hearing or mediation for the cases, arbitration hearing, post-arbitration briefs, and lastly, the final arbitration award. We move to our next slide, which is litigation. Next. According to Oxford Dictionary, litigation is the process of taking legal action. Litigation is the use of court system to resolve disputes. The process is from the issuance of writ by the plaintiff, appointed lawyer to the court against the defendant for hearing and proceedings. And finally, the judgment made by the judge. So both disputed parties will appoint or hire their lawyers that will represent them in court. It can last between 12 to 18 months and potentially longer time period to obtain the judgment. Next. Okay, so this is the informal method. Next. Next is negotiation from informal methods. Negotiation is the first method and the most appropriate method to resolve dispute because it is inexpensive and can maintain good relationship between the parties involved. The parties communicate directly with each other face to face or via telephone, email, text, and others, and there is no involvement of the parties. The result of negotiation is an agreement between parties. Next. Next is mediation. Mediation is the process by which the third party acts as a messenger between parties to assist in resolving dispute. The mediator helps define the issues, but parties must uh, create their solution by themselves. The mediator consult first with one party and then with the other. And if no negotiated settlement results, the mediator will make a recommendation to settle based on his own findings. The result for mediation process is a settlement agreement. Next. So this is the mediation step. First, parties will choose mediator and identify the objectives of both sides. After that, they will decide on mediation schedule, engage the other party in declaration position, and then discuss with mediator. Mediation, shuttle diplomacy, and lastly, endorse the deal. Next. Conciliation. So conciliation is similar to mediation, except for the active role of the conciliator. where conciliator can intervene during the process. The conciliator must be absolutely independent of the party to the contract, bring parties together for open discussion and cannot take any side or make any judgment. A conciliator also actively suggestion terms of settlement and comment on terms and brings dispute parties to acceptable agreement through concessions. So the result after the conciliation method is an agreement between parties. Next. So this is the last one of informal method, which is disputes review board. So dispute review board is a board of impartial professional formed at the beginning of the projects to follow construction progress, encourage disputes avoidance, and assist the resolutions of dispute for the duration of the project. So the board have representative from each contracting parties and mutually agree impartial third party and may meet informally for open and free discussion. Next. So that is all from dispute. So before we proceed for our next topic, I would like to ask all of you what comes to your mind when you heard about claims? So anyone?
Money.
Money.
Duit.
Huh?
Duit raya.
So what is the claim, class?
Money for the work we've done.
Okay, money with the work we've done. Other than that? Anyone? Okay, claims and payments, similar or different?
Difference.
Why is different? Class, I asked. I want to see how they answer.
Okay.
So, claims and payments are different, you said?
Yes.
The rest agree?
Yes.
Yes.
Okay, if yes, so what is the difference between payment and claims?
Claim is
Yes.
for the overwork we do.
Okay.
Payment is for the work that we do.
Okay, all right, correct. Okay, like that. That is the easy, simple, to understand. Okay, claim is usually for the overdue work. Okay, overwork that we have done. Okay, for example, like if they have the changes whatever, so meaning that it's not stated in the contract. Okay, the payment whatever as per agreed. Okay, that's the payment. Okay, for example, like if you working also, you can claim, meaning that when you have to do outstation, correct? You have to go out outstation and then you can do claim. But you got the salary. Salary is like the payment lah for you. Okay, clear? Alright, proceed, Shakira.
Yeah.
Okay. Next. So, according to Oxford Dictionary, claims is a demand or request for something considered one's due. Construction claim can be defined as a request by either party to the contract for compensation for damage caused by failure of the other party to fulfill his part of obligation as specified in the contract. And lastly, claims under contract and law. Contractual claim is an entitlement under the contract itself where specific provisions or implied condition of the contract can be invoked to support the entitlement. Okay, that's all from me. Next, Azwin will explain more about claims. Thank you.
Okay, Assalamualaikum and hi. First, I'm so sorry because suddenly I've got a problem with my camera. Okay. Okay, let's get started. Assalamualaikum and hi, I'm Nur Azim binti Harun. So let's go detail for claim. Okay, according to International Journal of Engineering, Research and Transport and Technology, there's about 8 types of contractual claim. The first one will be wrongful withholding of deposit claim. The second one is loss of profit, damage claim, different site claim, delay claim, price acceleration, change of work order claim, and also variation claim. Okay, can anyone tell me what is the causes of claim?
Respond.
Is there anyone that has an idea?
What is the causes
What
of
is the causes
claims?
of claim?
Problems or causes?
Causes.
Oh, causes. Class. What is the
Why
causes?
do you think these claims happen?
Sudden increase of work.
Sorry?
Sorry?
Sudden increase in the scope of work.
Kenapa tak dengar saja?
Sudden increase in the scope of work.
Oh, sudden increasing in scope work. One of it, is it?
Yeah, that's right. Yeah, it's one of these. Okay, actually the cause, it could be any one of these types of claim. Okay, let's see details. What is the causes of claim? Okay, the first one will be change of work of order. Okay, change of work of order, as we know that all project encounter changes during the progress. Okay, this happened when the owner directed changes to the contractor, which in return it will cause an additions of scope, revisions of the specification, and sometimes it could be they change the method of performing the work. Next is a delay claim. Okay, delay claim typically related to any circumstance which extend or prevent the project to perform as originally planned in the contract document. Could be because of waiting permit and approval or change of order. Usually it happens for a mega project. Then different site condition claim. A change condition that refers to some physical aspect of the project. For example, it differs materially from indicated by contract document or from originally or typical use method. Next, loss of profit. Loss of profit could be because of excessive change of order, an unforeseen event. Example of unforeseen event could be because of the weather or any incident that happened that we cannot expect. Okay, and then price acceleration claim. Price acceleration claim is where the client asks the contractor to speed up their work in order for them to increase their performance from the earlier date that they have agreed in the contract document. Hence, they were required to expend extra resources to compensate for the loss of time or sometimes to remain on schedule. Usually, this price of acceleration claim happens for the building of residential housing area. Okay, next is classes of claim. There's about three class of claim. The first one would be subcontractor claim. The second one is main contractor claim, and the third one is employer claim. Okay, for subcontractor claim. Okay, subcontractor claim is the, as we know that subcontractor is the major of the construction activity, and they play very important roles for the project to succeed. Okay, the subcontractor has the greatest potential for dispute because the subcontractor itself will do the paperwork and tender handled by individual with no formal training in legal matter. Usually, this subcontractor claim is filed by the contractor against the main contractor. And this happen usually because of the delay in payment release, design changes, short time period. Okay. Next is main contractor claim. Main contractor claim is usually because filed by the contractor, including with the subcon and supplier against to the client or owner. Okay, it is according to the agreement made between two parties on the variation. Example of variations could be because of the alterations of design, alterations of quality and quantity, working conditions, sequence of work, and many more. Okay, for loss and expense, relevant matter for which the client is responsible, such as discrepancies in contract document, instruction relating to variation and expenditure of provisional sum, failure to give the contractor positions of the site, failure by the client to comply goods or materials, and many more. The third one is disruptions of the normal progress of the work result in financial loss not otherwise recovered under the contract. Okay, as the progress of work has been disrupted, there is going to be additional cost. It usually happens when the employer hinder the contractor progress, or sometimes because of the architect negligence in carrying out his or her duty, which thereby cause the contractor to loss. Next is employer claim. Okay. Though in standard form of contract, generally it's skewed in favor for employer and not for the contractor. However, the employer can take any of the following form. Okay, the first one is an action against the contractor. Okay, action against the contractor could be because of defect that is discovered after the practical completion, or delay completion when there is no provision for NAD. Okay. Next is action against the architect or contract administrator. Usually it happens because of wrongful certifications of time, quality, and money. The third one is employer can take action against the QS, which is the quantity surveyor, because of the negligence of the QS in allowing the project to exceed budget. And for project manager, it's because the project manager allow the project to overrun in terms of cost and also time. Okay, there is about three nature of claim that can arise. Okay, the first one is claim arising from contract document, claim for differences in quantities, and claim in tender error. Okay, usually claim arise from contract document is because there is omission and discrepancies in the contract document, and for difference in quantity because there is variation in accurate measurement, or sometimes there is because of omission of temporary work such as the working and storage area, locations of the office, and many more. Then claim arising in tender error. It is because of inaccurate costing, drawing, and information, or sometimes a scope of the work has been modified by the owner. Okay. Next is contractor claim procedure. There's about 6 procedures to follow. The first one is notice of claim. Okay, the contractor will usually raise the notice of claim in a meeting, which supposed to be in a written form 28 days after the event giving rise to his claim has occurred. So, if the contractor fails to give notice in time, it will preclude itself contractually of any remedy whether that be for an extension of time or additional pay. So let's see what should be inside of the notice claim. So this is example of the notice claim. Okay, the notice claim should have the date of issuing the notice, and then the name of the organization, institutions that you wanted to issue. You must write the subject of your letter in a capital letter, and must clearly state the purpose of your notice, saying that you're asking for a claim or whatever. And then lastly, the signature name of you or the person that is issuing for the notice. Okay. The second one is contemporary record. Okay. Contemporary record is site diary, site record, weather chart, or anything that is correspondent with the anything happens that on the site that should be recorded in a paper. Okay. The contractor shall keep proper supporting record to substantiate his claim. Or in other words, it is like an evidence letter for you to make claim. Okay, the third process is that substantiation of claim. Okay, the contractor is required to submit a detailed substantiation of claim within 30 days from the date of his notice, or any date that is agreed by the superintending officer. The substantiation consists of the account in writing which gives the particular of the amount claimed. It is known as proof of calculation. The fourth step is access to contractor books and document. Okay, this is the SO. The SO must verify any claim that has submitted. So the SO must have full access to all books, document, paper, or records in possession for the purpose of making audit and examination. Okay, the fifth is payment of claim. Okay, the contractor will be paid based on the amount agreed during the claim evaluation meeting. And the contractor is entitled to an interim payment in respect to his claim for the loss and expense in the interim payment certificate. Okay, interim payment, it is the payment that you receive based on the progress of work that has been done on site. Usually for a big project, they will have interim payment. And the last one is failure to comply. Okay, if the contractor does not comply with the all above procedure, the contractor position may be compromised. As the SO is only required to access the contractor claim based on the limited information that is available to him. So if the contractor disputes the SO assessment, such dispute shall be decided by the SO. So that's it from me. Is there any question?
Okay, class, do you understand what is the process? Is it that's all from your group?
Yeah, that's all from us.
Okay, okay, class, do you really understand what is the claim, what is the dispute and what is the claims? What is the procedure and all? Are you clear? There is a dispute resolution just now. I thought that your group will really briefly try to make a comparison or how you want to understand the whole the dispute resolution types of dispute resolution just now your friend presented one. Shakira, is it Shakira part?
Yes, Doctor.
Right? Okay, I expect that your team will, I mean, the way you have to explain is must beyond that, you know. How do you want to differentiate between formal and informal, okay, in terms of the time, in terms of the cost, in terms of the difficulties. You got my point?
Yes, doctor.
So I didn't see that part of I mean, because it will show how you understand. It's not like just you read and then you just know what is the definition. That's it. It's not just like that. I expect that I already remind your class, I think, many times. I think none of your, I think your group still cannot. Let me show you. Okay, let me recaps. Because this I still don't know how to. I don't know how to advise you many times to do the presentation or try to understand the topic in a better way, because I already mentioned many times. Okay, you see the blank screen now, the blank board, right? Okay, everyone, when we talk about, I want you to get the point. How do you want to deliver a presentation, or in order for your, based on your understanding, okay? So, okay, let me show you. Okay, one part of it is the dispute resolution. Okay, okay. Recap again. What is the resolutions, right? Okay, so everyone, what is the dispute resolution that they give example just now? I mean, types of dispute resolution that they have. Informal and what? Informal and
Formal.
formal. Okay, so the first Shakira mentioned about formal. Okay, okay. So what else? Under informal, what they have?
Negotiation.
Okay, negotiation. And then what else? Sorry.
Maybe.
We have a few types, right? Okay, the rest, not only Tajul in the class.
Conciliation.
Conciliation.
Mediation.
Okay, mediation. What else? Ini je? Ada berapa kira?
Last dispute.
Dispute review board.
Dispute? Apa? Dispute apa?
Review board.
Review board. Okay, so this one still under informal. Is it? Okay. So what else? Class, please. Okay, that's all about informal?
Yes.
Okay, how about formal? Class? I should call them lah. Let me call, because I didn't hear other students. Hidayani?
Litigation.
Litigation. Betul? Okay. Let me ask. Okay, Shahida, what else? Formal. Shahida? Shahida tak ada. Umi Khaira? Umi Khaira pun tak ada, tidur.
Legal jurisdiction.
Yelah, what is the formal dispute resolutions? Other than litigation? Semua mencari ni. Alia?
Arbitration.
Arbitration. arbitration kan? Betul tak? Okay.
So,
So ada lagi tak Shakira?
No.
No, okay. In your presentation, you just mention, okay, formal, what is that? Litigation, arbitration, blah, 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 right? And then informal is negotiation, conciliation, mediation, blah, 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 betul? So did you really try to see what is the difference? Okay, so I thought that you will come out like, okay, for example, like this, okay? You can try to understand in a way like, for example, you see the time, the period that needs to solve the issue. Based on the definition, you can describe that things, you know. True or not?
Yes.
Then why don't you do that? Why don't you go that? For example, okay, let me try to show you. Okay, I hope that only left a few group, right? Only one group I think left, isn't it? Tajuk group tak tahulah kalau tajuk Prism macam mana. Okay, kita tengok tajuk Prism macam mana nanti with his team. Okay, so what you can make a similarity on the, what you can compare. Okay, for example, this dispute resolution, because when they offer the ways, okay, this one is how you want to solve the dispute, okay, in the construction industry. They have the option, okay, for the contractor, between contractor and client, if they have the problem or dispute, okay, how do you want to solve, okay? That's why they come up with this kind of practices, okay? So they have formal way, informal, okay. Do you know informal meanings that you solve between among that teams only, okay, with on site lah, maknanya informal they solve in on site, okay, but formal you have to go where to solve it?
Arbitrary.
I mean, you have to go to the
Court. Authority.
You have to go to the court, okay, to solve it. All right. So why don't you mention here, okay, in terms of cost? Betul tak? Because if you solve by yourself, you will see that it's not takes a lot of cost. And then here is the time, in terms of time. Betul ke tak? Or period, okay?
so
Time lah, time, okay? Here we put here. Okay, this is how you have to, once you explain blah 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 blah, you should have another one slide in order to summarize your topic about, okay, subtopic. I call this as a subtopic, okay? Up until this stage, I have to teach you. Okay, so this one high, kan? True, high cost. This one, low cost. Betul tak? So you have to try to understand the subtopic based on your creativity tau. You don't have this one different, maybe you, the way you explain, maybe you try to compare formal and informal je ke, or litigation different and arbitration different. People we explain in different way, but in my perspective you should see in this way, okay? Short term, long term. Okay, so now you see, if you want to indicate this kind of resolution dispute, how do you want to locate the formal and informal practice? In which part? Formal dekat mana you nak letak? Kalau you tengok, kalau you understand the what?
Di atas, ujung-ujung.
Paling atas. Okay, informal?
Cost very low. Lepas tu dia
Kat sini lah, okay. Dia bawah lah, formal atas. Okay, so you boleh tak try to ranking kan? Which one is in the informal dispute resolution punya flow? I mean the ranking tu. Mana yang paling dia kata tadi, which one is the most practice in the site? They propose which practice for to solve the dispute. Kan ada mention kan? Apa yang paling
negotiation paling
Formal
yang mana?
negotiation.
Negotiation please. Negotiation is the first option. Remember, in order to solve the dispute, the most simplest way or easiest way is a negotiation. Negotiation meaning that the client can consider what the contractor can do, or the contractor can tolerate what client wants, okay? This is a negotiation. They solve by themselves without any other parties, only between them. You got it? There is no other mediator or conciliator who involved, okay? You got it? And then next?
Mediation.
Mediation. Okay, and then next?
Conciliation.
Okay, conciliation. And then next?
Dispute review board.
Okay, dispute review board. And then?
Arbitration.
Arbitration. And then?
Litigation.
The last one. Okay. This can you see, can you make more understandable with this kind of picture slide? Shakira, nampak tak? You are supposed to show this way for me to see that, oh, you really understand it. But don't, okay, you didn't show that. Okay, your team member also supposed to come out in this kind of summary, or after your explanation, you should show something like this. Okay, you got it? What is my point?
Sorry, doctor.
So it's not about I don't like or what that. In your class, I see still all of you still weak in order to come up with the beyond your thinking, you know. I have to share with you how for you to have the critical thinking, or be creative, or be things out of the box. Okay, it's for you to understand the subject or the topic. It's not because I'm not teaching you the subject, right? But nowadays people have to learn by themselves, but we can guide. You got it? The point, because you have so many access, you get so many sources to gain the knowledge. So for me, it's a good opportunity for you as a student now that you have so many sources for you to get the information. Okay, not like us, last time we have to have a book, you know, to go to the library and find the books, which is very difficult. But now you have a Google, you have a internet, you have so many information out there, sources out there, that you should. YouTube also the easiest platform for you to learn. You got my point? And it's not about how you will collect the information, but after that you didn't know how to think to make it, summarize it, or to make it more understandable based on the definition. Oh, they have this one is easy to solve, so meaning that a short time to solve the issue, and if you go to the court, it will be long time, right? Is it difficult to think that way? Class? Okay, so I ask you. Okay, now you already know this how to differentiate. Okay, those are the resolutions. Okay, what is the difference between mediation and conciliation? Based on the definition that your friends already explained. Class. I kena panggil
It is the
seorang.
same. The difference is that conciliation has a third party involved.
How about mediation? How about the mediation? Tak ada third party ke? Class? I nak kena soal sorang-sorang ni tanya ni. Does you pay attention or not? I nak tanya siapa? Adelina. What is the difference between mediation and conciliation? Sebab mediation dia ada mediator, conciliation dia ada conciliator. Betul tak Syakira?
Betul.
Ada orang tengah. So what is the difference? Okay, Adelina, can you tell us? Adelina tak ada. Amalia? Amalia pun tak ada lah. What happened? Where you going? Diorang semua tak ada ni. Natra ada?
Ada, doktor.
So can you explain what is the difference?
I know the difference. That's similar but different is conciliated, third parties. Wait, I open their notes.
Ada notes ke?
Ada.
Syahidah masa tak balik lagi? Tak ada lah. Amalia pun tak ada. Adelina tak ada. Serius tak ada ni dalam kelas.
Ada.
Then explain lah.
Kejap tengah cari.
Amalia mana? Ni ada seorang-seorang suruh buka kamera ni. Ada ke tak ada ni? Boleh buat check up ni.
The difference is that the third party can involve in the dispute and the other one cannot involve.
Yang mana? Yang mediation tu cannot?
Mediation cannot involve.
Mediation cannot involve tapi ada mediator kan?
Yeah, but macam nak cakap.
Saya nak try boleh?
Okay.
Go Tajul.
Tajul.
Conciliation, dia bring together all the parties and then discuss. Tanpa conciliator tu make any decision. Biar party tu yang discuss. But mediator tu will discuss one by one. If tak ada resolution juga one by one, then mediator tu akan buat recommendation dia sendiri.
Bukan terbalik ke?
Terbalik.
Terbalik. Tapi betul lah you cakap tu.
Okay.
Terbalik kan? Terbalik.
Betul.
Terbalik, sorry.
Betul yang you cakap tu, cuma you terbalik kan? Maknanya during mediation tu yang macam you explain conciliation tu, they bring all the both party to discuss, okay, and let them decide. Okay, they bring, okay, mediation. During mediation tu, they try to approach both party, okay, to discuss what is the issue and then let them decide, okay, both party. So mediator is just like moderator lah, you got it? So they try to make a peace between the both party, but conciliation, they are not bring the both party. They cannot because one more thing you can compare is how is the worst of the dispute issue tu. Faham tak? That's why they cannot solve in that way. You got it, the point?
Yeah.
The worst issue. Nak kata the worst of depends on the issue tu. Issues the difficulties of issues tu lah. You got it? Here, dekat sini lah. Issues. So dekat sini Small issue, big issue, something like that. You got it? You use other terms pun boleh lah, as long as bring the same meaning, okay? You got it, the point?
Yes.
Small issue. Okay. And then dekat sini big issue lah. That's why they have to go to the court. You got it, the point? Nampak tak dekat situ? Okay, faham? Class? Small. You boleh letak dekat sini ke mana-mana lah yang you rasa sesuai, okay? So dekat sini actually informal kena buat up until here Macam ada satu line lagi ke so that you can make it different lah. Kalau tak nanti kan you tak tahu up until where. Okay? For example. Tu pun kena tunjuk Teruk lah you all ni. Nampak tak? Oh kecilnya. Okay. So nampak, so informal ni jatuh dekat sini lah kan? Right? Issues ni pandai-pandai lah you letak dekat sini ke small. Big issues. So issues is warna orange. So you faham lah orange indicated dia this one lah. So maybe this one you nak color lain ke, okay? You got it? Nampak tak? Nampak. So bila the small issue they can solve with the negotiate, okay? Both party have still boleh consider lah, okay? They can solve, okay? Because small issue. But if they think the issue is not that small, so they need the mediator. That's why mediator comes in, okay? To bring them because the issue is not really easy to go for the negotiation. So mediator have to help these both party to bring them in peace. And then other issue a little bit more difficult, so more complex. So mediator tak boleh buat apa pun. So they need a conciliator. Okay, the conciliator, what they did is they have to go to each party, okay, without meet them, in together, okay. Dia kena pergi, okay, dengar apa masalah dekat party satu ni, client, okay. Contoh apa, what is the issue, and then dia dengar pula yang dekat contractor side, what is the issue, and then they try to solve. The conciliator tu yang bagi propose solution, what they can do. You got it? And they will go to the party, that first client again to explain this is the solution that can do. And dia pergi dekat contractor again, this is what the solution can do. And they will decide based on, tell to the conciliator tu. Then conciliator will inform both party again. You got it? Dia tak akan jumpa sebab the issue is big, so they doesn't want to meet each other. The issue is already a bit critical, but still can solve. You got it? Okay. And then dispute review board, meaning that this project they have the board, meaning that usually the big project they have this dispute review board. So they settle within the team. Okay. So that one still can solve in formal. So for the small project usually they solve in negotiation, mediation and conciliation untuk informal, but it's a big company or big project, they have dispute review board. You got it? Clear? So they solve within the board. Okay, and then different between arbitration and litigation based on the issue, and also they have but arbitration they are not go to the judge. Kalau litigation they have to. But arbitration is on document wise, okay, documentation wise it's legal, okay, you got it? So it depends on the issue tu lah. Kalau the issue cannot solve and boleh cause, boleh disaman or the penalty, then they go for the litigation, okay? You clear? Nampak tak dekat sini how to so, macam ni lah to come out, okay? Tapi terbalik lah. Sebaik tak sesat mana you, macam ni you faham tajuk?
Saya baca notes. Tapi notes tu memang terbalik lah saya rasa.
Notes tu terbalik kan, kenapa?
Saya pun tak sure kenapa notes tu terbalik. Nanti saya tukar.
Macam mana notes tu boleh terbalik
Saya pun tak sure. Dia cakap yang conciliation tu yang bawa semua orang bersama-sama lepas tu bincang.
Oh ya ke? Nanti kita
mungkin notes ni silap kot.
Nanti kita, tapi yang lain macam ni, yang lain pun boleh macam je terbalik confirm je. You all really like you all jumpa notes lain tu?
Yang terbalik tadi tu baru cakap mediator tu yang buat keputusan kalau tak ada pihak lain yang buat solution macam tu.
Kalau dia still boleh jadi juga ke macam mana?
Tapi memang dalam notes ni cakap mediator tu akan buat keputusan kalau yang lain tak ada solution.
Okay. Kalau of course lah, kalau for example mediation, dia try to solve the problem but kalau diorang tak juga ada solution, of course lah mediator have to, sebab tu ada orang tengah juga. Faham tak? Tapi kalau conciliator dia takkan jumpa. Itu the different actually, yang the main part. Dia tak ada tak yang cakap dia takkan jumpa untuk discuss. Dia akan ada perbezaan yang tu. Sama ada mediator or conciliator. Conciliation. Mediation or conciliation. Kan ada kan kalau mediation tu dia jumpa ke tak?
Dalam notes yang saya download ni dia cakap mediation dia parti-parti tu tak jumpa. Mediator tu yang pergi jumpa satu-satu.
Okay. Nanti kita tengok balik. If I'm not mistaken, kalau tengok Sekejap kita tengok. Try to see Google. Easy, cepat. Sebab itulah your team have to do research like this. Dispute resolutions. Kita tengok, kita panggil apa ni, hierarchy ke? Hierarchy kot, okay. Kita tak hierarchy, hierarchy. Betul ke tak Okay, dia ada terms lain-lain juga ni. Kejap mana saya nak tunjuk sampel. Kita share tak? Okay, nampak tak? Patut those who make a topic, you kenalah cari apa namanya? Cari notes or cari information Okay, nampak tak? The dispute resolution hierarchy kan keluar kan? Okay, kita tengok which one is they have a few, so you must see kalau you nampak information tu sama, then you can accept it. Kalau you nampak lain-lain, you have to go find more and more lah. Okay, to make sure that the information is a collective correct. This how you want to find the information, but too many and too much, sometimes the researcher they already advance the theory. So the theory become more and more advanced lah. Faham tak? For example like this one, dia punya terms nampak tak? Dia ada grievance lagi. Apa benda ni? Tak nampak lah. I can't see. So negotiation always the first. Nampak? Dia panggil amount of controversy adversary. Nampak tak? So yang ni difficult how the issue is small or big lah, nampak? Lepas tu yang ni the consumption of cost and time. Nampak tak kelas? In any way how do you want to explain? So dekat sini ada adjudication. Nampak tak? Adjudication. So kalau dekat sini kita tengok after negotiation is mediation. Bila tengok mediation meaning that they still can meet up supposedly lah. Kejap Conciliation tadi boleh jumpa ke tak? Tajul?
Conciliation tu parti tu berjumpa, discuss.
Okay. So kita tak jumpa terms conciliation kat sini. Sekejap kita tengok dulu. Ni pun tak ada. Yang ni terus yang formal. Sekejap Kita tengok tak yang hierarchy keluar tak? Mana boleh refer Ni dia ada dua ni kot. Mediator standing. Okay, so what is the different, dekat situ dekat notes ada mention tak what is the mediator punya function and conciliator punya function? Ada tak? So I tengok ada tak yang boleh relevan. Dalam notes ada bagi tahu tak? Sekejap I cari. Yang ni saya ada lagi satu solution lagi ni. Assign opposing partner to come impartial decision. Yang ni yang macam, yang ni yang nampak tak? Dia assign to opposing partner. Maknanya dia tak boleh go for both side. Perasan tak? Adjudication ni. Tapi tak ada dalam notes kan? This one. Betul tak? This is it the right one? Mediator facilitates problem solving. Nampak tak? Non-binding recommendation. Conciliator explains the law. Okay? You nampak tak? I rasa terbalik tu notes tu kot. Itu notes you download Nampak tak kelas?
Nampak notes tu terbalik kot.
Kan? Nampak kan? Yang ni dia boleh, dia facilitate negotiation. Maknanya after negotiation tak perlu ada mediator kan? So and then next, you go for the mediation. You ada mediator. Orang yang tengah ni lah yang tolong facilitate the problem solving. Perasan tak? Memang dia akan, kalau ada orang dua-dua tak boleh nak bagi solve, mediator yang akan bagi dia opinion how to solve. But they can together Perasan tak?
Perasan?
Okay, so yang conciliation memang dia kena separate. Okay, so the conciliator yang akan explain what they have to do. Okay, after they got the information from this party and another party, and then the conciliator will brief, okay, everything. Right? Got it? So yang ni non-binding, maknanya dia tak pergi ke law punya ni lah. Kalau arbitration dia binding. Okay, the arbitrator tu dia akan based on the law lah. Yang ni dia just explain what is going on. If the problem is not solved, dia kena go for the informal part. Maknanya kalau dah try conciliation tak boleh solve, dia kena explain yang those party kena go to the law punya level. Maknanya to the formal lah punya dispute resolution. Clear? Okay, so please make it right the notes tu. So stick with this. Bila tengok kat sini clear lah macam yang tadi I explain tu. Faham tak?
Faham.
Clear
Clear.
Okay, boleh I think betul lah tu yang rasa notes tu terbalik. Betul. Notes tu terbalik Betul
Betul.
Ya.
Ni saya ada baca dekat internet
Okay, dia apa?
Dia cakap conciliation tu dia boleh sama ada meet ataupun tak meeting.
So apa beza dia?
Dia tak kisah. Depends on the conciliator tu.
Okay.
Sama ada dia nak kumpulkan ataupun dia nak buat asing-asing.
Okay, so maknanya sama dengan mediation?
Tapi dia beza dia macam dia send invitation dululah to both party. Kalau both party tu tak agree nak jumpa, so baru dia pergi one party by one party macam tu. Kalau both agree, dua-dua boleh itu.
Okay, lagi satu if I'm not mistaken, kalau mediator dia boleh jadi internal parties. You got it? Itu one of the different conciliator tu kena third party, orang luar, so dia tak ada bias. Betul tak? I think that's one of the different also. Okay? That one's the big difference lah. So but like Aslam found tu dia boleh sama ada jumpa atau tak, maknanya dia try to invite first. If cannot, tapi yang penting conciliator is a third party, mediator could be within the team project tu juga, within the team party's team tu juga. Okay? You got it? class? Boleh tak?
Yes.
Boleh.
Okay. But the flow is like this. It's like that lah, yang the one that I show you just now tu. Okay, the hierarchy tu, rank. We can. This is how you have to understand. If I assign you the topic, whatever, atau any other subject lah. Kalau you learn ke macam tu lah, you have to summarize it. You have to make notes how to make it the similarity, what is that, and what is the difference, how you can differentiate between that parts. Okay? Clear, right? So now we are almost 10. So the quiz, I think we proceed next class. So if any other question about this topic, we can discuss next week. Okay, I will refresh first. Okay, I will highlight what is the most important things you have to understand in this topic. Okay, I will discuss again next class. Alright, any questions?
Doktor, next week doktor explain ke? Doktor yang explain topik 8.
You punya
Saya
topik apa?
topik 9. Topik 9.
Topik 9. So topik 8 apa
Topik 8 termination ke?
Bukan.
Termination.
Bukan, jap. Iya ke? Jap. I rasa bukan lah. Termination ke? Contract termination. Betul. Alright. Okay, yeah. So I will explain on the contract termination.
Okay. Jadi lepas doktor present, saya present ke esok minggu depan ni pula saya?
You just get ready je. Kalau ada masa kita proceed. Kalau tak ada masa, you proceed the next, the following class.
Okay. Thank you, Doktor.
Okay, welcome. Alright, so only one more group, right, left? Because your class is not many students. Okay, so alright, nasib baik I tak marah-marah kan? Sebab I dah marah banyak kali kot. You punya kelas ni sama je. Malas dah nak cakap.
Sebab ada orang bagi duit tadi.
Sebab tu tak marah kan? Kalau tak memang kena lah. Habis pandai you all. Pow. Okay. Alright, so I hope that everyone got the benefits, the way how I explained to you. It's not about this topic itself. So it's about, I want you to become a competent graduate student. So you must know to use your brain to macam mana you nak think more creative or more advanced as in this new generation punya platform ni, sebab it's not easy for you to find a job, so you have to be put more effort lah on that. Boleh tak kelas?
InsyaAllah.
Okay, so alright, so I think thank you very much. That's all. See you next class. Okay,
thank you, Doktor.
Thank you,
Doktor.
Thank you, Doktor.
Welcome.
Selamat Hari Raya.
Thank you, Doktor. Selamat Hari Raya dah nak habis lah.